Oh, hi there folks, elder law attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, why do parents put their children's names on their assets? I see this all the time, folks, when we're teaching our educational elder law workshops in the community. And today I'm going to give you four big reasons why you should not put your children's names on your assets. Folks, you may know me as the author of How to Slay the Four-Headed Beast, the four-headed metaphorical monster, the four big things that folks are typically looking to avoid. So folks, if you like to read and become educated so you can have that metaphorical sword and shield to slay that four-headed beast, you can pick up a copy of our book on Amazon. Back to the question, why not to put your children's name on your assets? Number one, folks, capital gains tax. Write this down, folks, because taxes come in all kinds of flavors. I'm referring specifically to the capital gains tax. For example, if you own a home and you purchased that home 30, 40, 50 years ago, like a lot of our clients, you may have purchased a home for $20,000, $50,000, okay? Now you add your child's name to the deed to the property. Well, it all sounds well and good. It was simple. It may have been inexpensive. You may even trust your child. But now, folks, when you are gone, yes, you're going to avoid probate. However, number two, tax monster, tax man. So now in comes the capital gains tax. The tax laws say this, folks. If you make a lifetime inter vivos gift of an asset that appreciates like a piece of real estate, you transfer the property over to your child. Yes, you avoid probate, but now your child owns that property, okay? And if it's not their principal residence, folks, they are not going to get the stepped up basis, okay? They're going to take your original basis, what you purchased that property for, day number one, whether it's $20,000 or $50,000. We're using the example here, $50,000. Many years later now, you check out, your property is worth, say, $450,000. Well, since you gave your child a lifetime gift, they take your original basis at $50,000, selling it for $450,000. Guess what? Do the simple math. They have a $400,000 gain or capital gain. Capital gains tax, for general example purposes, about 20%, 15% federal, 5% state here in the Commonwealth, 20%. So $400,000 capital gain times 20%. Do the math there, folks. 400 times 20% capital gains tax, $80,000 bill. Will your child now be happy when their CPA accountant tells them they owe $80,000 in capital gains tax? Number one reason not to put your children's name on your assets in particular. All right, folks. Number two, what if you can become incapacitated and you need to sell that property during your lifetime? Well, guess what? If you're incapacitated now, your child's name's on the property, okay? And if you reserve what they call a life estate or a life estate interest in the property, like a lot of folks, then you will not be able to sign your name to that deed if you hold a life estate interest and you're incapacitated. Okay, folks? Other reasons would be financial creditors and predators, okay? Even if you trust your children, now they're going through times of turmoil. They have an automobile accident, a lawsuit, a bankruptcy, a divorce, in-laws turning into outlaws. How much of your asset now is put at risk, placed at risk to your child's financial creditors and predators, okay? Potentially all of it. If you put your child's name on your property within 5 years of the 5-year Medicaid look-back period, now you have a stroke, you have a medical catastrophe, and you're completely incapacitated, and you have the need to apply for Medicaid benefits and ask Medicaid to supplement or pay for your skilled nursing facility. Well, Medicaid application is going to ask, have you transferred any assets within 5 years from the date of application? And if you have, Medicaid is going to see that you added your child's name to your asset, and they're going to construe that as a gift. And they're going to request that your child retitle that property back into your name, because Medicaid is going to be interested in leaning your property if they're going to agree to paying for your benefits in return. So now you're giving up control, because now you have to rely on your child, maybe even your in-laws, your in-laws, son-in-law, daughter-in-law, to agree to have your child retitle that property back into your name, okay? So you're giving up control there. Number 4, folks, is if the house asset needs to be sold in your lifetime, if your name is still on the property and you deeded it to your child, and if you have to deed the property away and you're incapacitated, you may not possess what they call testamentary capacity, the legal capacity to sign your name to a deed. Without a proper comprehensive power of attorney, you may not have the legal authority to consummate that transaction. So folks, there you have it, 4 reasons to avoid or not to put your child's name on your property or your assets. There's more sensible, more prudent, wiser ways to do that. I would certainly recommend consult with your estate elder law attorney on what reason or what method or strategy may be the best, most appropriate for your situation. Folks, if you'd like to learn more, go to elderlawcare.com, because we have an educational academy there, and we have substantial videos and programs, and of course the book that you can continue to learn and read to become that educated consumer, so you too can slay that metaphorical 4-headed beast. Patrick Kelleher at elderlawcare.com.